morning, everyone, and thank you for joining us for today's session, where we'll be discussing co-ownership in residential transactions. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague, Robert Kelly. Good morning to you both.
Morning.
Morning.
Before I hand over to Ian, I'd just like to go over a few items so you know how to participate in today's event. You're listening by default through your computer speaker system. If you would prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. You also have the opportunity throughout the event to submit text questions to Ian by typing your questions into the questions pane of your control panel. You can send in questions at any time during the presentation. We will collect these and address them at a Q&A at the end of the session today, though. You can also raise your hand during the presentation, either if you're having IT issues, sound issues, or if you would like to speak to one of us directly through your microphone. So please use that option, and please do get in touch if you are having issues on the IT or sound side of things. Just finally, before I hand over, we've also included the notes for today's session in the notes section of your control panel. And we've also included some links to our YouTube channel and our LinkedIn page. Our LinkedIn page has details of all the webinars we run and news of new products. And on the YouTube page, you can find recordings of previous webinar sessions we've run, as well as some walkthrough guides of our online ordering portal. Anyway, that's enough of me rambling. Good morning to everyone, and I'll now pass you on to Ian for the main part of today's presentation.
Thank you, Steve. Thank you, Robert, and good morning, everyone. Thanks for coming along. I was just thinking as Steve was talking there, you know, I miss our Wednesday mornings. I must be sad, really, when I think about it, but I do miss a brief chat with Robert and Steve before we start, and then a presentation. And once again, big thanks to Stewart for organising these things. And again, a thank you to you all. Every time I'm sort of reminded of the number of people that attend these things, I'm really impressed that people are taking the time to come and listen to what we've got to say. Today, we're going to look at some issues relating to co-ownership. And again, there are some interesting points. And what I've done is sort of change things slightly. We're going to look at a co-ownership questionnaire that was devised by a barrister a number of years ago, a guy called Alan Tunkel. We're also going to have a look at some case law relating to co-ownership. And hopefully I'm going to sort of generate some new ideas and sort of repeat some of the basic principles with regard to co-ownership to stop complaints and claims being made. As Stephen mentioned, there is a chat facility. The last slide today will show my email address and the email address for Stewart Title. So if there are any questions arising from today, feel free to drop me or Stewart Title or both of us a note, and we'll endeavour to assist wherever we can. So let's think about co-ownership and why co-ownership is so problematical for residential conveyancers. In short, I think co-ownership is problematical for a number of reasons. Firstly, I think conveyancers, due to time constraints, due to cost constraints, make assumptions. So, you know, the property's been owned in the past by clients as joint tenants. Why rock the boat? Let's just ensure on the new purchase they do the same thing. Or what we're told, clearly there's an unequal contribution or a business relationship between the parties, and therefore we're automatically going to slant towards a tenancy in common. Well, point number one, we can't make assumptions at all with regard to co-ownership. It's a dangerous thing to make assumptions generally with regard to the conveyancing process. The fact that there's insufficient time during the process, insufficient fees to extract and assimilate information that our clients are generating is not really an excuse for not doing our job properly. It is important that we spend time making sure that we've extracted information from our client. It's important that we make time to decide what's best for the client. And of course, if we can, we should be charging for the work and the advice that we give. Certainly, from a perspective of professional practice, you cannot charge extra for giving advice relating to co-ownership generally. You can charge for advice relating to the preparation of and execution of a deed of trust, where you are using something like a land registry form JO, and I'm not necessarily encouraging that. You could charge for any time that was spent with regard to advice or drafting form JO, but as you'll see a little later, I don't think land registry form JO is worth completing except in one or two circumstances. Certainly, I wouldn't be completing it as a matter of course instead of using a deed of trust with regard to a tenancy in common. Co-ownership causes claims and causes problems because of a failure to record the intentions of the parties, or to have evidence of their intention, and to record advice when advice is being given. So this is really the sort of the framework of my presentation this morning. These are the things that hopefully we'll be looking at, we'll be exploring, and we'll be coming up with ideas to try and prevent problems or issues arising. And when I talk about problems or issues, I'm talking about negligence claims, and I'm talking about client complaints. As mentioned on a number of occasions in the past, in the good old days with regard to residential conveyancing, problems occurred and it was nobody's fault. These days, when a problem arises in the conveyancing process, it is invariably, from the client's perspective, someone else's fault other than theirs. And we all know, particularly with the SDLT issues that we've been having recently, that our friends, the estate agents, are quite keen to poke a stick at us and to encourage clients to poke a stick at us if anything's going wrong or anything's not proceeding properly. On that note, if we are going to be giving proper advice relating to co-ownership, my view is that we should be doing it as soon as we get instruction, rather than sort of meeting with the client or dealing with co-ownership as the transaction progresses. A lot of things we're going to be talking about today can be got out of the way very early on in the transaction, so that the client is properly advised and so that we're able to drive the transaction forward as we should be. We need to think about clients' intentions on acquisition. I'm going to mention the dreaded O word with regard to client's objective, but put this into the context of co-ownership. So why are we buying this property? Have we thought about the doomsday scenario if we fall out or if circumstances change? So let's just have a look at things. Mr. and Mrs. Smith come to see us, or a couple of parties that are sort of newlywed come to see us in connection with the acquisition of the property. It's not sort of it's not politically sound to start talking about, well, what happens if we get divorced? What happens if the relationship breaks down, etc. But we should be doing that. If a party or parties are coming to us and acquiring a property as a buy-to-let investment, so there's a commercial context to the co-ownership. Again, we should be looking right at the start, not just at clients' intentions on acquisition, but clients' intentions medium to long term as well. So I'm a great believer in saying to the client, what if? And I think we've got to do that with regard to co-ownership, and we've got to explain or make sure the client is armed with what they ought to be doing if that doomsday situation arises. The other thing I think it's important to do at the start of the transaction is to clarify from the client financial contributions, just what is being contributed, and for clients to be aware that where contributions alter, where circumstances change so that the beneficial interest alters, then the clients need to think about their position all over again. To that end, we can either suggest to them that the client sort of adopt a self-help sort of approach. Land Registry and indeed a number of consumer organisations on their websites explain to clients what can be done. I would always be maintaining that we should be saying to the clients, in a situation where there is a problem in the future, they should be coming back to our firm for assistance as to what can be done. Certainly when we talk about severing a joint tenancy, when we talk about registering Form A restrictions at the Land Registry, etc., my attitude is that the lawyers that acted for us in connection with the purchase should be our first port of call, where that's possible and where there aren't conflict of interest issues. So on this slide, there's a point I want to labour again. What are our clients' intentions medium to long term? If there is a falling out, if there is a change of circumstances, are we arming our clients with ammunition that enables them to extract themselves from the co-ownership? By that I mean severing a joint tenancy. By that I mean varying a deed of trust. By that I mean if the worst case scenario arises, are we telling our clients what they can do to extract themselves from co-ownership by application to court for an order for sale? It's that sort of thing, really, that this medium to long-term intent point is the point that I want to sort of develop. Now, what I want to do is just have a look at some case law to sort of support some of the things that I've just mentioned. And the first case I want to look at is a case called Turner against Bromett, Jackson and Heath, which is a 2016 decision. And here, fortunately for the firm involved, they were able to successfully defend a negligence claim that was brought to them. And it's quite interesting when you look at the facts of this case. There were some unfortunate circumstances that probably helped the defendant firm. One of which was the fee earner dealing with the matter went off sick. So not only did you have the confirmation of what had been explained by fee earner number one, but you also get fee earner number two, supporting and endorsing what was said originally, what client's knowledge was as a consequence of that original advice, but then that advice being supported by subsequent advice from fee earner number two. And that point, I think, is an interesting one. You know, frequently in a conveyancing transaction, we're not going to have the comfort of someone looking at the file, someone conversing with our client. Sometimes, you know, the conveyancing process, sometimes fairly frequently, it's a fairly lonely process of as a fee earner dealing directly with the clients. If we don't have the advantage that was given to Bromett, Jackson, Heath in this particular case, we've got to supplement our position by making sure that we're recording properly what our clients are telling us, what advice is being given to the client, and what the consequences of our instructions in our advice are. So in this particular case, what you had was an allegation that the firm had failed to explain the legal obligations and duties owed in connection with a declaration of trust. Now, a lot of you will say, we don't get involved in dealing with a declaration of trust. That's our private client's department's role. They draft the thing and they deal with the client in that regard. But as a conveyancer, it is important that our clients understand the legal obligations and duties that the trust creates and how that impacts on property ownership. The other allegation that was made here was that a sort of general point that where there is an unequal contribution by parties to the purchase of a property, there is a risk of a conflict of interest. There is a natural conflict of interest sort of always arising. And the court sort of dealt with this, and the court was actually a guy I know, Judge John Burns, nice guy, sitting in Leeds, and he explained, first of all, that the clients had explained to them that the nature of the declaration of trust, the content of the declaration of trust, and the obligations and duties that arose from it. So the judge was quite satisfied that a full explanation had been provided and that it was a bit rich of the claimant to now contend, because the declaration of trust didn't produce a satisfactory conclusion for her, that she would argue that she didn't have it explained to her or that she didn't understand it. On the conflict of interest point, again, the judge was quite scathing of the claimant and said there was clear evidence that the claimant was fully aware of her position with regard to her contribution and what the deed of trust was doing with regard to the beneficial interest. But the interesting point here with regard to this case is that the court emphasized the fact that there were two fee earners that were participating in this particular transaction. Both were singing from the same hymn sheet, and fortunately for both, there were attendance notes, file notes, and correspondence, which sort of confirmed the evidence that the relevant fee owners were providing. So, very interesting case, just highlighting some basic points with regard to the fact that we can't just get our clients to sign a deed of trust without explaining what it does and its implications in the conveyancing process, and implications with regard to property ownership ongoing and in the future. And this idea about a conflict of interest, quite clearly there is a conflict of interest in circumstances where clients are making unequal contributions and clients are not having the same objective with regard to initial acquisition and subsequent ownership. But just because there are unequal contributions does not mean there's automatically a conflict of interest. It is important to always ensure that when we are getting instructions in the context of co-ownership, we're getting instructions from our clients that are the same. Quite clearly, if in this case we were getting a situation where the claimant was saying, no, I'm not happy with what my partner is suggesting and I don't agree to what this deed of trust is doing, but I'm signing it reluctantly, the position would become slightly different. absolutely essential that we appreciate there is a risk of a conflict of interest, but the general rule, in my view, is as long as our clients are singing from the same hymn sheet, then it is fine for us to act, as long as the clients understand what the deed of trust is doing. So this case arose, in essence, because of unequal contributions, because of a dissatisfaction by one of the parties in relationship breakdown, that she wasn't receiving what she thought she was entitled to. The moral of the tale is, do think, going back to the point that I made a little earlier, about the client's position in the event of relationship breakdown, in the event that the world sort of falls apart with regard to the co-owners. Are we arming our clients with sufficient information to enable them to take the appropriate steps in those circumstances? The next point to note that I make in the notes, again, is the fact that it isn't necessary, courtesy of this case, for the parties to seek independent legal advice as a matter of course. The judge emphasised that there could be situations where the party should be separately represented and should be giving advice about the position relating to co-ownership, and then come back to the conveyancer to do with whatever they've agreed, assuming the parties have received advice and they are now in agreement as to what is to happen. The next point that I make towards the bottom of page 4 of the notes is that we've got to be careful in situations where clients receive advice from you, but then want to do something that is contrary to your advice. Now, that wasn't the case in Turner and BROMETS Jackson. That wasn't the situation. But do be alive to a situation where we've advised one thing and our client is doing another, that is an area where there is vulnerability for a residential conveyancer. All I could say is we must redouble our efforts to make sure that our clients are aware of what our advice is, aware that what they're doing is contrary to that advice, and aware of the implications that arise. Now, here's an important point from a practical perspective. I wouldn't be frightened about asking a client to acknowledge safe receipt of an email or hard copy letter confirming that what they're suggesting is contrary to advice. I wouldn't be averse to, if I have an attendance before the client via the telephone or Skype or Zoom, for recording that attendance, or making at the very least a full and detailed note of the conversation and sending it to the client, asking the client to confirm that it's a true record of the conversation and asking the client to sign it as evidence of that fact. Why? To go back to that fundamental point that I made a little earlier, clients these days are very good if something goes wrong or they don't get what they see as a fair hand of cards at a later date to blame someone. And it's easy to blame the residential conveyancer that acted for us 3-4 years ago on the basis that A, we haven't seen them for 3 or 4 years, B, we can't properly recollect what was said, and therefore there might be an opportunity for us to sort of expand on what our complaints are or retract on what we were advised. You get the picture. So I think the important point here with regard to Turner and BROMETS is that we've got a degree of protection with regard to this decision in connection with our role as a residential conveyancer. The next case that I want to take you through is the case of OXLEY and HISCOCK, which I'm sure you're familiar with in connection with the sort of co-ownership problems. And all I've done here is extracted a point from the Court of Appeal that said it's essential when dealing with co-ownership issues that we inquire about sources of funds. It's imperative in any event that we do that. But in a co-ownership context, it's essential that we understand the mechanics of how this transaction is being funded. And it's also important that the clients understand that where the dynamic with regard to contributions relating to subsequent ownership, alterations, repairs, extensions, refinancing, etc., where that dynamic alters the beneficial interest, that again a review needs to be undertaken of the beneficial interest relating to the property. But on acquisition, when we're acting for a buyer, where is the money coming from? Have we got our clients confirming the source of funds? Are our co-owners singing from the same hymn sheet? So they're telling us the same thing relating to sources of funds. And are we also, and again, this was extracted from Oxley and Hiscock, are we also inquiring about responsibility for paying the mortgage on an ongoing basis? Are we going to be nosy about our clients' circumstances and housekeeping so that we can be quite clear that there isn't going to be a change with regard to the beneficial interest that should be recorded as a consequence of later contributions being made by one party that are greater than the other? The key here is, and Oxley and Hiscock is a sort of great case for this, make sure we're getting sufficient information from our clients at the start in order that we can properly advise our clients about their position on acquisition and their position in the future. I do mention in the notes that we should be explaining to our clients choices. I also mention in the notes an important point, that we should be differentiating between clients in a sort of social context that are married or in a civil partnership and those that aren't. And the reason for that, on extracting quite a lot of the sort of family case law, you can see that where parties are married or in a civil partnership, then the law is able to redress any imbalance that arises due to poor advice or poor decisions that are made relating to co-ownership. So in a marital situation or civil partnership situation, then the courts have a discretion to a degree how to divide assets. But that isn't the case with regard to a commercial relationship in a co-ownership context, or in circumstances where parties are not in a civil partnership and are unmarried. I think we've got to be even more careful with regards to that. And again, I mentioned in the notes, Stack and Dowden, Jones and Kernet, the idea that we've got to be careful about initial contribution and also making clients aware that the subsequent contributions that are made, not just financial contributions, can impact on how the court will determine a beneficial interest at a later date. Now, I am conscious of the fact that a lot of this will go above and beyond what a residential conveyancer would be expecting to provide by way of information. I'm not asking a residential conveyancer to give the client a huge sort of diatribe about the workings and vagaries of sort of family law, or the vagaries of constructive trusts and the attitude of the courts. All I'm saying is we just want to highlight to the client, hey, if you're making contributions with regard to repair, maintenance, alterations, extensions to the property, if you're refinancing, you do need to think about how that impacts on the beneficial interest that you possess or own relating to the property, and it might be wise to consider taking a review of the position with your lawyers, just to make sure that what you're doing or what you're intending to do is properly recorded. And what I've done, or what my colleagues in the private client department have done on acquisition, isn't outdated by your changing circumstance. So just to be clear, I'm not saying, you've got to write a sort of 30-page essay on Stack and Dowden and Lady Hale, etc., and her position with regard to contributions. Far from it. We neither have the time nor the inclination to get involved in that sort of discussion. I'm just saying we make clients aware of the fact there could be changes, short-term, medium, long-term, that need addressing. So going back to this slide then, choice. We've got to advise clients as to the choices that are available to them. A joint tenancy, tenancy in common and equal shares, tenancy in common and unequal shares, and don't dismiss the idea of the property being held in the name of one party as opposed to both. So if your client is about to engage in some high-risk commercial activity, or your client is in a situation where they own other property and there are tax issues at large, then it may be appropriate that the property is held in the name of one party only, or more accurately, that the legal title is held in that manner. Again, caution would have to be exercised with regard to the party that becomes the non-owner, and steps taken to afford protection in those circumstances. And again, be alive to the risk of conflict of interest. So, I mention in the notes that once we've decided, or the clients have been advised and the clients have decided the choice that they wish to take, then we've got to have a look at that and delve a little more deeply into the advice that we're going to provide. So, if we think about a joint tenancy, and our clients have been told and have decided that a joint tenancy is for them, we need to explain what happens on the death of one of the joint tenants. I have to tell you, in my experience, when I've gone into firms and looked at their standard letters, that is always dealt with. The doctrine of survivorship is beautifully explained. What I am concerned about is some firms do not explain what happens if both joint tenants are killed in the same incident. And again, I've had cause to be involved on the periphery of an issue where precisely this happened. Two parties killed in a car accident, and of course the situation there is the youngest is deemed to survive the eldest, where they were killed instantly. Well, in those circumstances, the doctrine of survivorship applied, and the entirety of the value of the property was devolved by the younger party's estate as a consequence. Are the parties aware of that? Are the parties, with regard to a joint tenancy, available or aware of the fact that a unilateral severance can occur relating to the joint tenancy? So again, I'm going to show you some case law that deals with that led to a negligence claim. The negligence claim failed due to a limitation point, but again, it just sort of highlights the dangers of failing to explain to the clients the implications, the significance of what they are doing. I mentioned in the notes, and I mentioned on slide here, some more practical problems with regard to a tenancy in common. If the parties are holding the beneficial interest as a tenancy in common, do the parties have a will? And what happens with regard to that will? Where does the beneficial interest in the property vest on death? How will that impact on the surviving tenant in common? Bad enough for there to be a bereavement, even worse that the devolution of the beneficial interest to a third party means that the family home is to be sold. So again, it's not necessary to give clients in-depth advice about what are, in essence, private client matters, but it is important for the client just to be aware of the potential situation and the doomsday scenario that could arise. I mentioned it is important to understand that with severance of a joint tenancy, the general rule is that there will be a 50-50 split with regard to the beneficial interest. I am going to show you a case where there was a severance and an argument that the beneficial interest was not divided on a 50-50 basis when a joint tenancy was severed. More on that in a moment or two. In the notes, I look at some practical problems relating to co-ownership, item 3 of the notes. I'm not going to dwell on that any further. We've discussed most of the issues that I think are appropriate. I do think it's important then, when we're looking at the death of a tenant in common, that we should single out the position where tenants in common are married, on the basis that there is an opportunity for an aggrieved surviving tenant in common to make a claim on the deceased's estate, but when the tenants in common are not married, the likelihood of such a claim being less beneficial for the surviving partner. So again, it's important, I think, to not just advise generally, but look at the specifics of the client's own circumstances. Again, important that the clients are advised about the need for a will. Important that where we're dealing with tenancies in common, the clients are advised of the need for a declaration of trust. And it's important that that declaration of trust is not used simply as evidence of how the beneficial interest is to be held, but the deed of trust should manage the trust on an ongoing basis, dealing with, for example, how the co-owners can extract themselves where circumstances warrant extraction. What is to happen with regard to the mechanisms for sale of the property, and of course what is to happen with regard to distribution of proceeds. I mentioned in the notes that we should also be thinking about client considerations. And just to sort of go through these things, again, reiterating choice. The clients can do whatever they want to do, as long as they are giving you instruction on the basis of informed consent. So they have to be informed, they have to understand before being in a position to decide on their choice of co-ownership. The clients need to be aware that their choice will lead to the potential, if they're choosing a tenancy in common, for additional documentation to be prepared and for a cost consequence. And again, I reiterate the point that it is dangerous in simply relying on the transfer and the tick box with regard to how the beneficial interest is to be held, or the use of Form JO to be a replacement to a deed of trust. Neither would be an adequate replacement. A deed of trust should be prepared for the reasons that I mentioned earlier. Other points that the clients need to be aware of: the ongoing relationship. What happens if the parties fall out? What happens if the purpose sitting behind the trust no longer exists? Again, from my experience, where the co-ownership arises due to a business relationship, these issues are taken into account properly and appropriately. But frequently that is not the case where you're dealing with a sort of family co-ownership, partners, husband and wife, etc., that we're not thinking what happens in the event of a fallout, or where the purpose for which the trust was created no longer exists. And I think the last point on the slide is important. When we talk about considerations for the client, what is to happen if something occurs relating to the co-ownership in the future? Is the client aware that you as a firm, or indeed you as a fee owner, are able to assist with regard to what happens next? Or is the client provided with information as to where they can seek additional information or advice without recourse to you? Again, it's important to understand that what we're doing here is we are managing client expectation with regard to the conveyancing process. And of course, in addition to that, what we should also be explaining is the fact that it's not just the initial purchase, but it is the long-term relationship between the co-owners that we are devising some form of mechanism for management. The next thing I want to talk about is severing the joint tenancy. Sorry, I'll just go, yeah, this slide here, sorry about that. Yeah, severing the joint tenancy. A number of points to note. Again, when I'm looking at standard letters from firms of solicitors, I'm sometimes surprised that whilst the firm will advise the client that a joint tenancy can be severed, they don't explain the procedure and they don't explain the significance of severance. Now, I'm going to show you a case where both of those issues were live and potentially meant the firm of lawyers involved was negligent. Important, but we'll come along to that case in a moment or two. Generally speaking, of course, only a beneficial interest can be severed, and of course it's important that we understand and our clients understand the process by which severance can take place. The obvious one, compliance with section 36(2), notice in writing. Interestingly, there is case law that suggests this doesn't actually have to be a formal notice, but if there was a letter or some form of indication that the co-owner wished to sever, that might be sufficient. Again, there is a need for service of the notice. In addition to that, where we have a falling out or discussion as to what is to happen with regard to the trust and the property, then Williams and Hensman, Burgess and Rawnsley, the old case of Re Wilford's estate, all suggest that it isn't necessary for formal notice to be served. Acting on one's share, using the beneficial interest for security for mortgage, attempting to sell the beneficial interest, attempting to sell the property. Negotiations that don't quite reach the stage of a final agreement might be enough. Burgess and Rawnsley leaving the door open, but of course, from our perspective, far better that there is a formal agreement and that formal agreement is properly recorded in writing. And again, as I say, Re Wilford, mutual conduct might be enough. So clients need to be aware that if they wish to sever, written notice is the best way of proceeding. Clients also need to be aware of the fact that someone should be dealing with Form SEV or RX1, depending on circumstances. SEV, registering a restriction without the other owner's agreement. Form A, restriction using Form RX1, where there is consent. It is important that the clients are aware that in addition to the process of the land registry and the use of Form SEV or RX1, it's necessary to submit supporting documentation. Now, okay, let's just analyze this for a moment. Am I really saying that we're going to give our client a crash course in how to lodge a Form A restriction at the land registry? No, I don't think it's necessary to go into the detail that the notes prescribe. But I do think it's important that the client understands how you sever a joint tenancy, notice, and the submission of a document at the land registry that enables a restriction to be placed on the title, so that the world at large is aware that this co-ownership is now a tenancy in common. So I don't think, as I say, we have to provide an essay to the client with a flow chart showing the mechanics of the land registration process. I just think we have to ensure that clients are aware that this can be done. And it's perfectly proper to say, hey, you need to come to see us or to see solicitors or conveyancers to assist you with regard to this process. The next point that I want to mention is a point that I touched on a little earlier, and that's this case of Singler against Brown and Malden Brown, 2007. This was the case where you had an insolvency of a co-owner. And in essence, there was an argument about whether the notice of severance was a mechanism to try and avoid the beneficial interest of the bankrupt falling into the hands of the trustee in bankruptcy. So that, in essence, was the background. And the court was having a look at whether or not the severance constituted a transfer under value. Just for the record, it could have done, okay? Notice of severance served. The notice of severance was quite interesting in that it didn't just sever the joint tenancy, but it stated that the party severing the joint tenancy now wanted the property or the beneficial interest in the property to be held as tenants in common in unequal shares. And surprise, surprise, given that the male party was about to be made bankrupt or had been made bankrupt, was certainly in financial difficulty, the beneficial interest was now to be divided 99% in favour of our solvent co-owner, and surprise, surprise, 1% in favour of our insolvent co-owner. Significantly, our insolvent co-owner signed the document, acknowledging receipt of the notice and accepting the apportionment of the shares stated in it. Now, here's where our solvent co-owner was fortunate. In essence, what this notice was doing was accurately recording the actual state of the beneficial interest, given her significant contribution to purchase price and subsequent contributions. So she could back up that the reality was that she owned 99% of the beneficial interest and he had a sort of notional or nominal interest in the property. Unusual to have that. Normally this type of situation is a mere sort of sham to try and avoid trustee in bankruptcy receiving the beneficial interest or a half share in the property. But it just shows you that you could serve a notice of severance indicating how the beneficial interest was to be held, and that the court would be willing to accept that if the division of beneficial interest in connection with the notice was supported by evidence to confirm that contributions had been made that would reveal, in fact, 99% of the property should have been held by the solvent party. The next case that I've given you in the notes is Boycott against Williams. And this is an interesting case because Mr. Boycott acquires a property for him and his girlfriend. And he, in a fit of sort of generosity, which perhaps is rare for a Yorkshireman, he decides that the property will be held as joint tenants, notwithstanding the fact that he was buying the property with his own funds and resources. He alleged that the solicitors acting on behalf of the purchase failed to advise him that girlfriend had a right to sever and that she could do so unilaterally. What he said was, had I been aware of that, there's no way I would have been as generous. Because, in essence, or by implication, I don't trust her. Okay? The court received evidence that there was a communication from solicitor to Mr. Boycott explaining the doctrine of survivorship, and that the doctrine of survivorship was vulnerable on the basis that the nature of the joint tenancy could be altered at a later date should it be required. Girlfriend falls ill, not sure whether she's aware that this illness is going to lead to her demise. There was a falling out of the property, falling out of the parties, and an issue arises with regard to her estate and the property. Because notice of severance had been correctly served, the half share that Mr. Boycott thought was going to revert to him didn't. Now, what was the position here? Okay, the position was the notice of severance was valid. The position was that the court was satisfied that Mr. Boycott had received advice with regard to initial acquisition and the notice of severance. And fortunately, although there was a view that the advice that he'd received was defective in that it wasn't clear as to what the significance and consequence of the notice of severance was, for the solicitors involved, liability was avoided due to a limitation point. What does this case highlight? What can we extract from this case law? We need to be scrupulously careful about what we explain to clients with regard to severance, not just a throwaway line that a joint tenancy can be severed, not just a small paragraph explaining it can be severed and the significance of severance. But I think we've got to explain to a client the method of severance, the consequence of severance, and the fact, and I think this should be sort of a capital letters and bold print, the fact that the tenancy can be severed unilaterally, and there's nothing that the fellow co-owner can do about it. It is immediately transmitted into a tenancy in common in equal shares. There is an added point that I think is significant, that where a notice of severance is served on a co-owner, and that notice of severance purports to confirm how the beneficial interest is now held, if that notice confirming how the beneficial interest is to be held in the future is to be disputed, it must be challenged on receipt. And it certainly, no matter who asks, shouldn't be signed for or acknowledged without challenge. That's the Singler against Brown point that I think is important. So I think it's important that we extract quite a lot from that case of Boycott and Williams. And the other point that I want to emphasize is I think it is also important that clients understand and the practitioners understand that the placing of a Form A restriction on a title does not of itself change a beneficial joint tenancy to a tenancy in common. There is a necessity for notice to be given or for evidence of agreement or evidence of intention to be put. Now, we're lucky in that the Land Registry should ask for that in connection with supporting documentation that is submitted along with Form SEV or RX1. But again, we've just got to be careful. With regard to tenancies in common, again, the basic points, of course, we deal with this in the notes. Firstly, of course, important that clients understand the doctrine of survivorship does not apply. Important that we have evidence of contribution, particularly where there is agreement that the beneficial interest is to be held in unequal shares. Important that clients are advised of the need for a deed of trust, and significantly that the deed of trust is kept under review. Now, again, I just want to emphasize this point that most firms will have a private client department that deals with a deed of trust. Well, that's fine. You as a conveyancer, nonetheless, would still have to explain to the client the significance of that deed of trust in property law terms, and the significance of the fact that a failure to keep it under review could have drastic consequences. The reason for that, if we go back to Stack and Dowden, is that the courts are saying that where there is documentation which records the status of a beneficial interest, the court will be reluctant to look behind that unless there are exceptional circumstances. So if there is a deed of trust sitting there that was prepared by a lawyer on acquisition, I have seen the courts determine that the fact that the beneficial interest alters is irrelevant, that the court won't look behind the deed of trust. That sort of stance would then lead to the aggrieved party perhaps looking at their conveyancer or those that prepared the deed of trust to see if a negligence claim can flow on the basis that there was a failure to advise when the deed of trust was created for the deed of trust to be reviewed. I mentioned in the notes, and I mentioned on slide, of course, that it is possible for a beneficial interest held as a tenancy in common to be changed to a beneficial joint tenancy. But this can only take place with agreement of the co-owners. So it's not creating the vulnerability that a unilateral severance of a joint tenancy creates. I mentioned that to convert a tenancy in common into a joint tenancy, it would be necessary to cancel the Form A restriction using Form RX3, and that supplemental evidence is provided to the Land Registry. Interestingly, I had an email yesterday from someone about a Form A restriction, and the question that was put to me, this isn't in the notes, is if that is the case and a tenant in common dies, does a Form A restriction protect the executors or administrators of the deceased tenant in common? And the answer to that is no, it doesn't. So the question that's then put to me is, well, what do we do? Well, you can lodge a Form N or a Form Q restriction, but to do that, you'd need the consent of the surviving tenant in common. Where you can't get that consent, all you can do is place a notice on the title as a sort of prerequisite to litigation. And the other point to note, really, with regard to a Form A restriction, remember, all restrictions on registered titles are not cast in stone. They cannot blight a title. They can't prevent a disposition of registered land. They must be capable of being complied with. In the notes, I've given you information relating to Form JO. And although JO was utilised by the Land Registry, created a number of years ago, in essence, with the aim of making it easier for joint purchasers to make a declaration of trust within the document, the reality is that Form JO falls significantly short of the creation of a declaration of trust. JO useful where the conveyancers don't wish a transfer signed by the seller to leave their possession, useful for evidence for the land registry as to how the beneficial interest is held where a transfer is not submitted. But other than that, Form JO is of little value. Which leads me to the next point that I think is significant. There have been a number of cases where the courts have been left with an interesting predicament, namely, what is the position where a TR1, which records how the beneficial interest is held, is not signed by their buyers? Well, what I've done in the notes is given you some case law to have a look at this. The interesting position is that Taylor and Taylor in 2017 raised an interesting point with regard to the purchase of a hotel and a campsite. The TP1 included a tick in the joint tenants box. The document was executed by the sellers, but not executed by the buyers. And despite the fact the buyers were father and son, there was a falling out that led to litigation. Father said, I contributed 80% of the equity, and he claimed that the declaration of trust that the father and son would hold as joint tenants was irrelevant because he hadn't signed it, and maintained there was a constructive trust in his favour. The father also argued, when his son raised the issue, or his son's lawyers raised the issue, that the sellers can't declare a trust on behalf of the buyer. The court disagreed with the father's contention and said the sellers signed the transfer, and in doing so, they signed as legal and beneficial owners, and they were capable of declaring trusts on which the property was to be held by the buyers, meaning father lost his 80% beneficial interest and instead was awarded the 50% that the tick in the box and the transfer document generated. In so funding against Dowie, same sort of circumstances, but different position from the court. Buyers tick the joint tenancy box on the form, but the court held the fact that the sellers had signed the form did not declare the trust on behalf of the buyers, so directly contrary to Taylor and Taylor. The court emphasising, which I suppose is a fair point, that the TR1 should be properly executed by the buyers. The court held in so full funding that Stack and Dowden applied, namely where domestic property is acquired in joint names, the presumption that co-owners hold the property as beneficial joint tenants, and the fact there was a discrepancy with regard to contributions wouldn't usually displace the presumption. The court, however, emphasised it was a presumption that was capable of rebuttal depending on circumstances. So if there was evidence, as I mentioned in the notes, of the parties intended to the beneficial interest to be held differently, then the presumption could be rebutted. The point really to make here is that the case law is inconclusive. The buyers should be signing the TR1 to confirm the position. Be interesting to see what would be the position if the TR1 wasn't signed, but then Form JO was. And my guess would be the court would say in those circumstances, the combination of the two would be sufficient to determine that the TR1 or TP1 was evidence as to how the beneficial interest would be held on the basis it was supported by the Form JO. Conclusions, because I'm conscious of time. We should be using co-ownership questionnaires. We should be explaining choices. We should be listening to clients. We should be offering of advice, but on the basis that we're assuming nothing. and we should have evidence to support what we've been told by our clients and the advice that we've given. With tenancies in common, we should be advising that a deed of trust must be used, even though there's a cost consequence. We should explain what the deed of trust does and significantly how it deals with issues going forward. We should explain to clients where a joint tenancy is agreed, the doctrine of severance. We should explain to clients what should happen in the event of relationship breakdown and the need for the joint tenancy to be severed. And we need to retain records of instruction and retain information relating to advice and clients' understanding of advice. In the notes, what I've done is given you the cohabitation questionnaire that was devised by a barrister at Three Stone Buildings in London, Alan Tunkel, who has authorised me to disclose it to you. This is what he describes as a cohabitation questionnaire, but I've put it in there. I don't think it is the perfect document, but it is a useful document, and it highlights a number of points that we've made. Significantly, it explains in basic terms the concept of co-ownership, the doctrine of survivorship, how survivorship impacts on inheritance, how co-ownership and mortgages interplay, and in addition to that, it looks at why a property is being acquired and the purpose sitting behind the trust and what happens when that purpose comes to an end. It also highlights the fact that if circumstances change, documentation needs to be changed. It asks for the purchase price and how the purchase price is being funded. It therefore gives you detail as to what the parties' contributions are so that you can check what is being proposed with regard to the beneficial interest is evidenced by contributions. It also asks the parties to confirm how the beneficial interest is to be held and asks the clients to confirm in writing the position with regard to mortgage payments ongoing. So all of these things sort of support or give you ammunition in case problems or issues arise. I'm going to finish at that. As I say, I am working currently on a variation of Alan's form to sort of update it and to try and look at some other points that I think could be mentioned. But if nothing else, it provides a very useful framework for you to compare against your own questionnaire or to assist you if your firm doesn't have a questionnaire at the moment dealing with co-ownership. Stephen, my ramblings are now at an end. I'm happy to take questions if there are questions. As I say, the questionnaire is within the notes, so delegates are more than welcome to look at it. And Alan Tunkel has no objection to the legal profession utilising it. In fact, he's quite delighted when people do so.
That's great, thank you. Ian, as Ian said, we're now going to begin answering questions submitted during the session. As a reminder, you can still submit questions through the questions pane in your attendee control panel. Ian, a couple of questions around the advice on severance. I think that was really when some questions started to.
Yeah, I thought it would.
Through. Yeah, and obviously you made the point about sort of advising clients, but perhaps not needing to go through the whole process in detail. And I think the sort of pitfalls and lessons from Boycott and Williams. But Mark Carnes asks, should clients be advised as to how severance can occur other than by notice?
Yeah, I think so. I think so. Just giving them a flavour that it might not be a sort of a formal notice. It might be something that is inadvertently done. So I think that would be wise. Mark raises a great point, as you do, Steve. The Land Registry used to publish Public Guide 18 that used to deal with all of this. And what I used to say to people is just give the client a copy of Public Guide 18. Public Guide 18 is no longer published by the Land Registry. Some of the information that was in Public Guide 18 is now available on the government website. But I think, yeah, I would be telling a client it is possible for a joint tenancy to be unilaterally severed by notice, but it is also possible for course of dealing, discussion, agreement to constitute severance. Just so the client is aware that this isn't a sort of one co-owner going legal and serving formal notice. It could be more informal than that, but still having significant consequences. Great question from Mark. Thank you.
Yeah, thank you. And one point Mark raises, and I think you've covered it off there really, Ian, is the idea, could it entail a proverbial essay to the client? And I think that's a balance really that you were trying to suggest that is trying to be struck. But
well, the way I would deal with it, Steve, is to say to a client, look, there's a proper way of dealing with this, which is notice of severance, but be aware that a number of meetings, be aware that conduct may amount to severance. So where you have the slightest inclination that there's a falling out between co-owners, you should really be getting advice from someone before doing anything or saying anything or meeting with anyone. That would be, I think, the way I could reduce my essay into 2 or 3 lines.
Perfect. Thank you, Ian. And yes, thank you, Mark, for that question. Sort of similar lines, really. Alistair asks, if we acted for both parties, can we act for one of them if they split up? I assume we would have to ask the other for permission. Is it better we do not for either? Do not act for either?
Yeah. Well, one of my first boss used to say to me, there were 2 things to watch out for. I was put this is on, I think, my first day of my training contract. One was watch out for clients who appear to be idiots or lunatics, and make sure you don't act for them. Rule number 1, okay? Rule number 2, if there's the slightest hint of a conflict of interest, don't get involved. Because if you do get involved, it is quite difficult then to extract yourself from a situation where a conflict arises or a conflict becomes apparent. One of the best lawyers I've ever met, actually, to be honest, Steve. Great guy, long retired these days, but always a very clever guy. I always remember he said to me as well, I expect you to make mistakes, but if you make a mistake, you tell me about it and you don't make the same mistake twice, which was quite an enlightened attitude, to be honest with you.
Yeah, very, very good advice, I would say, actually. Yes.
Yeah.
Thanks, Ian, and yeah, thank you, Alistair, for that question. This next question, Ian, I'm not sure if this is with reference to the appendix. Sorry if I missed this myself, but Ian mentioned he was working on a questionnaire. Will this be shared with us once it has been updated, revised?
Yeah, what I was going to do is say, as a sort of an Easter gift, we'll share that with people. So once it's finished, and actually, to be honest, I'm waiting for Alan to come back on a point. Then I'm quite happy to share that with everybody.
Perfect. That's excellent. Rico, thanks for that. And
just thinking about that, Robert and I had an exchange of emails recently because someone was asking about what causes negligence claims. And what we might do as well is sort of share that. And I haven't finished and I haven't forgotten about our book of questions, Steve. Remember?
Oh, yes, of course. Yeah. No, I haven't forgotten about that either. The
problem with that is every time I get anywhere near closure, I get another raft of questions. So it's a sort of moving feast. But I haven't forgotten about it, and we're getting there. I have to say we're getting there. Perhaps you could impose on me an Easter deadline for that as well. That might be useful.
Absolutely, yes. Yeah, we'll discuss that for sure. Thanks, Ian.
Good.
Mayumi asks, when the property stroke sort of price value is over the IHT threshold, 2 times multiplier, to what extent do you think we should flat up the IHT liability on each of them in holding the property as a joint tenant? Brackets, as tenancy in common and gift between spouses are exempt of IHT currently.
Yeah, certainly it's an issue. You can either deal with it or say to the client, look, there could be issues here in our private client team. Need to give you some advice. But I would certainly flag it up as an issue. That's a great point and something that you should do. But you know, again, it depends on the scope of your retainer. But certainly, you should be flagging up there is a potential tax liability here that can be managed, courtesy of the method which is used in connection with the co-ownership. Yeah, good point.
Perfect. Thank you. Just one final question, Ian, from
Yeah.
Sally. I'm foreseeing we may need to take this one offline, but I'll put it to you anyway.
Yeah.
So thank you for the webinar. So thanks for your comments there, Sally. A client owns a slither of land with a sibling as T and C. The actual house and mortgage is just in one of the siblings' ownership, and they wish for the slither to be transferred. How can we force a transfer if the sibling continues not to respond to correspondence? No declaration of trust was entered into. Brackets, we didn't act. Thanks.
Right. So what could be done? Well, it is held in joint names, but there isn't a declaration of trust. The situation there is, I think you're into an order under Section 14 of Talata for an order for sale. Was it Sally you mentioned, Steve?
That's right, yes.
If Sally drops us a note by email, we'll have a look at it, but I'm immediately thinking about Section 14 Talata, order for sale.
Perfect, yes. No, I think that's best. I think if we take that one
offline.
But Sally, please do get in touch with us and email that across. That'd be great.
Yeah.
Perfect. I think that's everything for the questions. So thank you, Ian, and thank you to everyone for submitting the questions and for attending today's webinar. Just as I mentioned in the intro, we have included links in the chat section to our new YouTube channel and our LinkedIn page. Ian also has a LinkedIn page that we will share as well. Please do give us a like or a subscribe if you do use these platforms. That would be very useful. If you have any other questions that you didn't get a chance to submit today, please do contact Ian or myself after the webinar. As is always the case, once you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this email, the replies come to me directly, and I can send any questions or feedback on to Ian. You will also receive a separate email from my colleague Robert Kelly, which will contain the slides and notes and recording of today's session. And just to note that we will be taking a very short break for Easter, but I'm delighted to let everyone know that Ian will be joining us for a new series starting on the 12th of April, where Ian, I believe, will be discussing environmental issues in residential transactions, which I think will be a very interesting session.
Yeah, brilliant. Thanks, Steve.
Fantastic. So just on behalf of Stewart Title and of Ian Quayle, thank you for joining us today, and have a great rest of your day. Thanks, everyone. Goodbye.